they can say there is in the record a rescission. There is not in the record any objection to the rescission. And they were given a mortgage 1 year following the notice of the final notice to cancel. So that it was after the statute of limitations.
All right, has your statute of limitations ended on your rescission?
Yes, the 1 year following the rescission.
You didn't file an action against them?
No. Well, see, that's what the federal court was for, but that got dismissed.
So you did file an action against them for failure to within a year period of time?
No, I waited.
After a year?
Yeah, because if you do it within a year, they can come back and ask you for all the rest of the money.
Okay, so that was Leslie and Colin discussing rescission as it relates to foreclosure. And I wanted to go back to that because it's actually a very interesting case of how sovereign citizen theories get hatched and get promoted through the internet. This started with Neil Garfield in early 2015. In his blog, livinglies.wordpress.com, he posted information claiming that you could basically rescind your mortgage and therefore not be foreclosed upon and basically be able to keep your house. And he based this on Jastrzębski v. Countrywide Home Loans, which is a Supreme Court decision. Now, don't get the wrong idea, he was not doing this out of the goodness of his heart. Garfield was selling packages offering this rescission analysis package for $1,995. So let's keep in mind here, he was offering these packages for $2,000, claiming that this Jastrzębski argument would allow you to keep your house if you stopped paying the mortgage. First of all, let's read what the Supreme Court actually said. They said, quote, "A borrower exercising his right to rescind under the Act need only provide written notice to his lender within the 3-year period, not file suit within that period." Or in other words, as the summary reads, you only need to provide a notice that you're going to rescind within the 3-year period. It does not require you to file a lawsuit. Now, Garfield it twisted this decision to mean that you could rescind your mortgage by sending a letter, and you won't be subject to foreclosure, and you can keep your house. Now, if we go to Leslie's case, which is a woman who was speaking at the beginning of this audio, quote, plaintiffs alleged that they had rescinded the mortgage under TILA, and thus the mortgage was void. The court found that there was no rescission of the mortgage, and it accordingly granted City Mortgage's motion to dismiss that case. In other words, her attempt at rescission failed, and the court explained that she could not rescind it because she was outside of the statute of limitations, the 3-year time limit. Now, before we go further, the right of rescission is codified in 15 U.S.C. 1635. And here is what Garfield has not told his customers. If we go to subsection E, exempted transactions, this section does not apply to a residential mortgage transaction. In other words, there is no right of rescission for residential mortgages, which is what he is advertising his rescission package for, and what Leslie is trying to do. She's trying to rescind a residential mortgage. Now, Leslie is not the only person to try Garfield's rescission argument. In Meinhardt v. CMG Mortgage, Meinhardt sued in 2016 arguing a TILA rescission claim. He claimed that he executed a right of rescission notice June 25th, 2016. So let's keep in mind this was after Garfield was promoting his stuff. And that Nation Star failed to respond within the required 20 days. The court responded, Meinhardt's TILA claim is irrevocably flawed because the limitations period for such a rescission is a maximum of 3 years, and Meinhardt waited 10 years. They go on to say, quote, TILA gives borrowers the conditional right to rescind certain loans for up to 3 years after the transaction is consummated, but the unconditional right to rescind lasts only 3 days. The right to rescind is extended only if the lender fails to make disclosures. There is no statute or case holding that the rescission right may be exercised 10 years after the loan is consummated. Meinhardt's TILA rescission claim is fatally flawed, and it cannot be amended to make it plausible or viable. And then there's Meinhardt's remaining claims all depend on his allegations that the wet ink note is unaccounted for, that it was forged, securitized, or that he obtained only vapor money. So this guy was trying other sovereign citizen arguments, such as, the wet ink signature argument, and they all failed. So let's keep in mind, this guy was a sovereign citizen trying to avoid his foreclosure. I was also able to find Brown v. Bank of America, in which another woman used the rescission argument, and the court rejected it. Quote, Brown's claim that U.S. Bank failed to recognize her purported rescission notice, which she sent to U.S. Bank on August 7th, 2015. Let's keep in mind, this was after Garfield's blog post. Fails because a rescission notice must be sent within 3 years of the consummation of the loan transaction. A loan is consummated for purposes of TILA when the loan is closed with the execution of a note and mortgage. In this case, according to allegations, the loan closed in September of 2006. Brown did not exercise right of rescission within 3 years of the consummation of the loan. The loan was consummated in September 2006, but Brown did not send her rescission notice until 9 years later, in August of 2015. Thus, Brown did not timely exercise her right to rescission. And continues. Brown suggests, however, that the 3-year limitation is subject to equitable tolling because she was not aware of the rescission provisions of TILA until the Supreme Court's decision in Desinovsky. Let's keep in mind, again, this is the Supreme Court decision that Garfield is citing. The court discusses that and responds, Desinovsky does not support Brown's equitable tolling argument. Now, I was able to find a presentation by a law firm which discusses the implications of Desinovsky for borrowers, and they do point out some interesting things. Quote, if successful, rescission essentially gives a borrower a free house for a period of time. Even if ultimately deemed invalid, a rescission claim can delay for years the disposition of any pending or future foreclosure action. In the meantime, the borrower can continue living in the home for free. Under Desinovsky, a borrower who defaults has an even greater incentive to rescind. In other words, the lawyers do recognize that rescission can work to delay foreclosure, but it does not mean that you will never be foreclosed. It just delays it. But the important slide is the theories of liability slide, in which it explains all the ways that the bank can foreclose upon the property and get their money back. And it lists getting a judgment for the unpaid balance of the loan, foreclosure, in other words, sell the property to satisfy the unpaid balance, declaratory judgment to get an equitable mortgage, damages equivalent to the unpaid principal balance of the loan. So basically, no, this is not a silver bullet. Your best case scenarios are you're going to delay foreclosure. But the people like Garfield who are selling this advice at $2,000 a pop are lying when they say that you'll be able to keep your house without paying your mortgage. That simply isn't true. Rescission will not allow that. Now, one final point. According to Garfield, his $2,000 rescission analysis package is his, quote, most popular service. Now, I was able to find about 40 cases of people trying the Desinovsky rescission argument in court. It's not clear how many of them got the argument from Garfield, but I know at least Leslie did. Now, let's assume that half of them got paid Garfield for these services. That's $40,000 in Garfield's pocket from giving fraudulent legal advice. And let's keep in mind, all of these people lost in court. They got foreclosed, they got evicted, that he lost. And in Leslie's case, for example, she filed a whole bunch of federal lawsuits, state lawsuits, all trying this rescission argument, and those lawsuits are not cheap. In one federal case that she filed, it cost her $400 to file that lawsuit, which failed. That's money and food coming out of her pocket. She's an old woman. She's going to lose her house now, and she won't have money at the end of it. To try and find other housing, and all of that. So at the end of the day, people like Garfield are really evil. He's making $2,000 a pop, giving advice that does not work in court, and costing these people their homes and their money, and it's absolutely disgusting. And the courts and the authorities don't do anything about it. This guy has his website out there in public, and why this guy's not in jail is beyond me. I would rather see this guy in jail than, say, some kid that's smoking pot. This guy is doing real damage to the world.